weeks ago, the guy that wrote the land trust book, Mark Florida, who's an attorney in St. Petersburg, Orlando. He's an attorney in Orlando. He wrote this book on land trust, which you can buy on his website, Develop Press, for a very affordable price for a law-related book, and it comes with a PDF of all the forms, so it does enable you to get going. The advantage of this text is that it's Florida specific. So anytime you're out getting real estate education and you're working in Florida, you have to realize that if it's a California law book, it doesn't have anything to do with Florida. So any materials you get have to be Florida specific or they're useless. All right, so that's the bad news about putting your Ohio properties in the trust, is that I'm not sure Ohio has such a thing.
They do.
As land trust.
They do.
Good. So there are only a few states in the country, I think 8 or 10, that even have a land trust, 7. So the vast majority of states don't have land trusts. And even in Florida, I'd say the vast majority of attorneys don't have any idea what a land trust is, despite the fact it's been on the books for many years. So rather than getting into the nuts and bolts of creating a land trust, I'll just tell you what a land trust can do so you can decide if it's useful for you. So essentially, a land trust is a method of holding title to real estate in which you divide the legal ownership from the beneficial ownership. So I think an analogy that makes sense to me is if you think of a corporation has a president that runs it, and then it has stockholders that own it. So in a land trust, you have the trustee that does the business of the property, like signing deeds and signing mortgages, and then you have the beneficiary, which is the true owner. So that's like the stockholder, but you don't see the stockholders going and signing contracts with people. They're just the owner. So in a land trust, you split the ownership between the person on title, the trustee, and then the true owner, the beneficiary. So why is that useful to you? So in some cases, you don't want the public to know that you're the owner of the property. So last week in my newsletter, I wrote an article that said the perils of the anonymous member LLC. So what's a peril to someone is a benefit to you, the property owner. So what were a couple of those perils? That since no one knows who owns the property, that means the building department doesn't know who's breaking the building code. So they may say, that guy Alex Johnson is the worst slumlord in Broward County, but they're never going to know that I'm the owner of the property. So to the extent that they put you on a list that they don't like you, they're not going to ever know what you own. So if you have one property that's in trouble, they're not going to go and inspect your other properties. The other thing is that sometimes, like in the case of a celebrity or a millionaire, they really don't want it known where they live or what they're buying. Just in my office recently, we had a multi-millionaire buyer who paid the highest price for a condo ever in Sunny Isles, like tens of millions of dollars. He really didn't want it known that he paid that much and it was him, and they screwed up and it got out. So if he had done a land trust, no one would have known who bought that. He would have accomplished his goal of buying that property without anyone knowing either the price or the ownership. So the famous story of the land trust is Disney. When Disney wanted to have Disney World in Orlando, obviously if Disney arrives in town and starts buying up farms, it's going to be fairly obvious he needs to buy them all to have a property the size of a whole county. So he came in and apparently got the land trust statute passed for Florida in order to come in as hundreds of different buyers. So now no one ever figured out that it was the same guy buying everything that he possibly could. So that way you could own property without people knowing that it's you. So why is that good? Let's say you get in a car accident and someone just goes to bcpa.net, the Broward County Property Appraiser puts in your name, Alex Johnson, boom, up comes a ton of properties. They're all commercial. I've got tons of unprotected assets. I'm a good person to sue. So if it's in land trust, and I do own all my properties in land trust also, if you typed in my name in the property appraiser site, or even in the recorder of deed site, nothing would come up. So you're not there, no one knows your business. Let's say your tenant is mad at you, that you've evicted him and he wants to kill you. So you can type in your name and nothing's going to come up.
And he slips and falls. And he slips and falls and has an accident. And he wants to sue
Or,
you.
as happens frequently during an eviction, the tenant slips,
Right.
falls down the stairs and he wants to sue you because he's being evicted. Well, now the only thing that owns the property is the trust. And the amazing thing about the trust statute is it says, and this might have been a mistake, but it still says this. This is Florida Statute 689.071, and you should write that down because, how many pages is this? 1, 2, 3, 5 pages legal size. So you can read it yourself, that's the statute. All the Florida statutes are online, easily obtainable. So 689.071. So it provides that neither the trustee nor the beneficiary is liable. So that guy falls down the stairs, I'm not liable, the trustee's not liable. So what's you got left? My insurance policy and the property itself. But not me, there's no deep pockets other than the real estate itself. So let's say that I own everything in my name, the guy falls down the stairs and sues me. He's got me, he's got my house, he's got my insurance, and he's got every other house too. So that is not smart planning. Or the building department gives me a fine for whatever reason. Because the guy before me did an addition with no permits and I got caught, and they tagged me for it, they put a fine on the building. That fine attaches to that building, and if it's in my name, Alex Johnson, it liens every other building that's in the name of Alex Johnson. So the advantage of the land trust is that now you can have all your buildings in separate names for no real extra expense except the paperwork. So let's say I have this place, ABC Chinese Restaurant, it could be the ABC Chinese Restaurant Land Trust. And then if I own the hair salon over there, it could be the Hair Salon Land Trust. And then Eurodeli Land Trust. So it may be me that owns all the shops in the mall, but they're all titled differently. Now I could have Charles as my trustee, so it could be Charles Hayes, trustee of the ABC Chinese Restaurant Trust, the Hair Salon Trust, the Eurodeli Trust. So Charles can do all my transactions for me, sign my deed, sign my purchase contract, sign my leases as the landlord. So he's running the show. Someone wants to sue somebody. Charles is not going to be liable for any lawsuits, but he can run everything for me. I'm still the beneficiary. I'm ultimately going to collect the rents. So now I've separated myself from the trust. All right, some other benefits. Probate. So if you have properties and you don't provide for a beneficiary and you pass away, you will have to file a probate in Florida. So like a lot of my clients are snowbirds, so they only own rental properties in Florida, they don't live here. But if they were to pass away and they didn't arrange for a beneficiary in the title to the property, they would have to open a Florida probate. And that's sort of a pain in the rear for poor planning, because that's going to be thousands of dollars and take months, where your property is now tied up in limbo. Because if it was owned by Alex Johnson and there is no more Alex Johnson, then the owner of the property is nobody until they open an estate and create a new legal entity that represents me. Then the court appoints an administrator. But in between, when I'm dead and the administrator is appointed, no one owns the property. So it can't be sold, it can't be borrowed against, you're in trouble. But there's an easy fix. So the crude way would be to put a right of survivorship on the deed. So you could do it like that, but in a trust it's a little simpler, because once you've set up the trust, you can appoint successor beneficiaries in the trust. So let's say that you have your nephew as your successor beneficiary, and then he pisses you off, so you want to strike him out and put in your niece. I don't have to file a new deed knocking him out as my successor or the right of survivorship. I just change the trust, which is not a recorded document. So when I take title to the property, it's deeded to the trust, the ABC Chinese Restaurant Trust. Charles Hayes, trustee. I can switch the beneficiaries all day long, every day of the week, for free. It's not a recorded document. So I can have multiple beneficiaries, I can have successor, I can change them. So now, if I pass away, all my properties go to the successor beneficiary without probate. It happens automatically. Also, I didn't need to record new deeds every time I changed my mind. The other thing about deeding your properties, let's say that I have the ABC Chinese restaurant and I bought it in my name, and now I went to a seminar and said, geez, I should put it in an LLC for asset protection, but I have a mortgage on it for $100,000. Well, as far as the government's concerned, if I deed it from myself to myself in a single member LLC, I have to pay sales tax at 70 cents a hundred for that transfer. So I would owe this county $700 sales tax. So, like for you, if you're doing that with a bunch of properties, $700 times 20, that's an expense you could have avoided, because deeding a property into a trust is legally not a change of ownership. So if I have a property owned by Alex Johnson, I put it into a trust, and the beneficiary is Alex Johnson, it's not a change of ownership, and legally, I don't have to pay any doc stamps. So by putting it in a single member LLC instead, I would have had to pay $700 doc stamps for having a $100,000 mortgage. Into a trust, that's a freebie, no doc stamps at all. Okay, creditors' claims. So once again, I'm in a car accident, somebody's suing me, the property's in a trust, not in my name personally. They are not going to go after the property. If they get a judgment against me, it does not attach to the property. The name on the judgment has to be the same as the name on the deed. So as long as those names are different, any judgments you get don't touch your properties. I told you about the liens, the same thing. As long as the name on the lien isn't the same as the name on the deed, the liens and judgments don't spread from one property to the other. Another thing is that land trusts are immune to a claim for partition. So if you do business with partners, and let's say that it's an LLC or you have multiple owners on the property, and the partners have a disagreement about what to do with the property. One of them wants to keep working, one of them wants to keep it as a rental, the other partner wants to liquidate. Normally, the remedy is for the partners to sue each other and demand partition, which is forced sale of the property. So that can't be done on a property in a land trust. So that way, you can have a partner force you to sell your investment property against your will. So no partitions on land trusts. Lease options with the land trust and safer mortgages. So one, I can tell you as a landlord-tenant attorney, one of the big perils about giving a tenant a lease option is that the option gives them equitable ownership of the property. So that means if the tenant knows what he's doing and he hasn't paid the rent and you're evicting him, he just raises the flag, hey judge, I'm not only a tenant, I have an option to buy the house. So that really makes me an equitable owner. And what does that mean to you? You're kicked out of eviction court, and now you have to go back and file an ejectment, which is the legal equivalent of a mortgage foreclosure. So now you're up in circuit court, where it takes 4 months to get a court date, and it's going to take you a better part of a year, and now you're trying title plus possession. So instead of an eviction where it's all said and done in a couple of weeks, now you've got a whole year in court. And what's happening during that year? You're not getting any rent, but you are paying taxes, you're paying insurance, and you're sitting there, this guy's living in your house for free, you're paying legal bills, and so you win a year later. You know, did you get paid back any of that? No. So if instead of a regular lease option, you were to give the tenant an option on the beneficial interest in the land trust, now they can't come into the eviction court waving the flag, I've got a purchase contract here. Because one of the things that happens with a land trust is you legally convert the real estate into personal property. So now your tenant doesn't have an option to buy real estate, he has an option to buy goods. So that is completely legally different than a right to buy the real estate. So he's not going to be able to pull you up into circuit court doing an ejectment by having an option on a beneficial interest. So likewise, you're talking about hard money lending. There's a very nice thing if you're a lender using the land trust. And I've got clients that are hard money lenders that do this regularly. So this is like a super mortgage. The lender takes title to the property. The lender is the trustee of the trust. All right? So that means the lender has the keys to the property. Nothing can happen to that property without the lender. It's like the lender is the owner. The borrower is the beneficiary of the trust. And when they borrow the money from you, which is different than a regular situation, because in a regular property, the borrower has the deed and the lender has a lien. So for the lender to protect themselves, they have to foreclose the lien. In the land trust scenario, the lender has title and the borrower has the beneficial interest that's liened by the land trust mortgage, which in this case, since property in a land trust is now not real estate anymore, but goods, it's called a chattel mortgage. Chattel is a legal term for goods, like a car. So when you have a car loan and you miss your payments, does the car loan company file a foreclosure?
No.
And you're in court for 6 months, or a year, or 3 years? No. They come and tow your car.
And
The
do
car is
repossession.
gone. So what is the land trust equivalent? You tow their car by sending them a letter, dear borrower, you missed your payment, the beneficial interest was your collateral, I'm hereby revoking your beneficial interest. Now I, the lender, who am also the title holder, have revoked your remaining interest, so now the two halves are merged, I'm the owner and you're nothing. So the borrower is out, they were never entitled to begin with, you don't have to file a lawsuit, so the foreclosure is done for free and in no time. So very good tool for a hard money lender. They're just out. And we've done that a few times, it's never been contested. There is no case law on it, so I won't say that it's ironclad, but there's no case law in the other department either. Avoiding reassessment. So going back to the scenario where I decided to put a property in my name into an LLC, once I record a deed, the property appraiser, his ears go up and says, hey, the property's sold, let's reassess his market value. So the property appraiser reassesses properties either by like a blanket assessment of whole areas or by the actual sale of your property. So anytime a deed is recorded, they look at your property and see if they need to reassess its market value. So with the land trust, I am changing ownership without recording anything. So there's no ping against the property appraiser for reassessment. All right. All right, deficiency judgments. This is sort of playing on the ignorance of the lender, but let's say that I buy a ABC Chinese restaurant in a land trust to get my $100,000 mortgage. Legally, the person signing off on the mortgage is the trustee, Charles. So let's say that the lender is not really doing their homework and they let Charles also sign the note. Well, Charles isn't obligated as trustee on the note, so essentially they end up with a note with no one's signature on it. So now nobody is liable for the debt. It's like a no recourse loan. So that's something lenders, again, since it's only 7 states, lenders are often completely unaware of what a land trust is or the terms. So you'll see them insisting that the trustee signed, but that's an empty signature. Due on sale clauses. So if I have a house with a mortgage on it and I want to stick it into a trust, as long as the first beneficiary is the same as the grantor, that is under federal law not a transfer of ownership. So there's no due on sale violation. So if I wanted to then sell the house to Charles subject to, or to Edison subject to, I put it in a trust to me, and then that's not a due on sale. So Citibank calls me up and says, what's this trust? And I'm like, look at the St. Germain Act, that's not a transfer, that's not a due on sale violation, you can't hold a loan. And then I can give the beneficial interest to Edison, and he can hold that property